Hey everybody, how's it going? Welcome to Daily's 2A News. Today we're going to be talking about oral arguments that were heard earlier today by the Supreme Court in the NYSRPA versus New York carry case. This is a very important case. There was a lot that was said, a lot that happened, a lot that didn't happen that I was expecting to hear, but still, it was a really important day today. This is the first time that the Supreme Court has heard a major Second Amendment case like this in a long time. So let's talk about what happened. Now, just in case you guys don't know what's going on here, let me go ahead and give you a brief explanation. This is the New York State Rifle and Pistol Association v. New York. And what the NYSRPA is saying is that New York's rules, regulations, and requirements for obtaining a concealed carry permit are unconstitutional. That's wound its way through the court system, and now it's found itself at the Supreme Court. Traditionally, the Supreme Court doesn't take Second Amendment cases. They haven't in a long time, and so we've seen decades go by before, they've actually heard a Second Amendment case, and so that's why it's a big deal, is because this is the first time in a long time that they've heard something like this, and this has broad implications across the entire country. For those people that are in California, maybe LA County or other places that have very similar requirements to New York, this could basically change all of that. So again, it's a very important case. Now, oral arguments were pretty much exactly as you would expect. There's two different sides here, and I want to thank Armed Scholar for providing the feed that I was watching earlier. But you have the one side, the NYSRPA, which is pro-Constitution, pro-Second Amendment. You have the state of New York, which is clearly anti-Second Amendment and not pro-Constitution because that's part of the Constitution. So you have the two different sides, and each side has to argue their case to the justices of the Supreme Court. Now, as the NYSRPA was arguing their side of it, they would take questions from the justices. Each justice asked a bunch of different questions. Sometimes they offered some pushback to some of the things that each of these attorneys was saying, and so they offered some pushback, and that offered us some insight into their thought process, which I found was really interesting. Now, the Solicitor General of the state of New York did an absolutely terrible job. I didn't think that she was effective for the state of New York whatsoever. So the Solicitor General, I mean, you could have completely removed her from the argument altogether, and it probably would have been better for the state of New York. The NYSRPA, they did a great job. The person who, the other person for the state of New York, actually did a better job than the Solicitor General arguing his points. But what I found interesting is that the pushback and the thought process that I was seeing seemed to lead to more confusion, and I'll tell you why. So you expect that, like Sotomayor and others, who are completely anti-Second Amendment, right? You'd expect them to have more pushback against the NYSRPA. You'd expect them to ask questions that kind of lead them into the direction of trying to disprove their point. So you expect them to be anti-Second Amendment, and that's kind of what you got, right? But then you have others like Amy Coney Barrett and Kavanaugh and others who, you would expect and hope that they would be pro-Constitution and pro-Second Amendment, and I didn't really pick that up. Amy Coney Barrett really wasn't present much at all. She just kind of hung around and didn't really speak much. Kavanaugh left me scratching my head and wondering exactly where he stood. I wasn't 100% where he stood. I wasn't even 50% where he stood. I was just completely lost on where he stood. And then you have Justice John Roberts, who, if you ask me, I kind of expect him to fall more anti-Second Amendment than pro-Second Amendment, but surprisingly, he ended up being, in my opinion, a little bit more pro-Second Amendment, at least in his line of questioning, in the direction that he was kind of taking the questions. You could tell that he might be actually on the side of the Second Amendment on this one. So it seemed like the justices that were anti-Second Amendment pretty much held their ground. You could tell that they were not going to have their minds changed. So I'm not expecting a positive vote from them. But from others who could be on the fence and maybe fall either way, that's where my confusion was. I didn't really get any type of feeling of pro-Second Amendment anything really from those particular judges. And so it's going to be really interesting to see where this ends up. I think, now, just in my own personal opinion and based off what I've heard and things that I've read and kind of following this case, I think that we're probably going to get a win out of this. But if we do, it's going to be very, very close. I think that this is going to be a very close call. It's probably going to be decided by one, and it's not going to be a big majority win or anything like that. But I think we are going to see a win for the Second Amendment on this one. But again, it was just, you know, you listen to the anti-Second Amendment side and you just scratch your damn head the whole time thinking, how could you possibly think this, right? You know, I mean, one of the things that he said is, it's common to regulate things like this. We have a history and tradition in this country of rules and regulations that are similar to what the state of New York has now. And this is very common practice. And while saying that, he said that 7 other states also practice something similar to New York. Now, I don't know about you, but a majority is what's considered common. So if you're saying it's common and then you say only 7 states out of 50 are doing it, that would mean, to me at least, that it's uncommon, right? Only 7 out of 50 are actually pushing rules and regulations similar to New York. That means that 43 states are not. So the 43 states that are allowing freedom and constitutional carry and permits and so forth, that would be common. That would be common. The 7 states that aren't doing, you know, that aren't allowing constitutional carry and freedom and permits and stuff, those are the ones that are uncommon. But for some reason, he was trying to make his point by saying it's common because 7 other states do it. There was some weird things that happened like that, and you know, different arguments that kind of popped up that made you scratch your head. But all in all, it was pretty much just a back and forth. We think it's unconstitutional. We think it's constitutional. Here's why. And then that was pretty much the end of that. There wasn't anything really exciting that I heard to report to you guys. It's just basically, this is my side. This is my side. These are the cases that we're referring to, you know, that happened in the 18th century, 19th century, and 20th century that give us some type of precedent, and go ahead, judges, make your decision. Now, we're not going to see a decision on this. They pretty much never rule from the bench. They're going to go ahead and take this information back. They're going to mull it over. They're going to research all the cases that were brought up, and they're really going to look at this, and then they'll come up with a decision. So it'll probably be I'm thinking it'll probably be maybe not till February of March of next year, 2022. But we'll see what happens. Regardless, it's definitely something to stay on top of. So, you know, hey, let's hope for a win for the Second Amendment. We got to try and keep our heads up on this one. Thank you all very much for watching. I really do appreciate it. Please like, subscribe. Have a great day.